make sure he hits the OK button on his invite to change to a panelist, please.
Okay, I hope you heard that. Mr. Colby, hit the OK button on the invite. There he is.
Thank you. Just got that notice.
All right. Mr. Franklin, you're up, I think.
Thank you, Your Honor. Good afternoon, everyone. My name is Jonathan Franklin, here on behalf of GEICO. If the court would permit, I'd like to reserve 5 minutes for rebuttal. The case before the court involves 11 consolidated suits that went to trial and involves a final judgment that is not based upon competent substantial evidence. The 11 cases that are present were involved automobiles insured by GEICO in 2016. The 11 automobiles had some form of windshield damage that was repaired or replaced by Glasgow in 2016. Glasgow invoiced GEICO for the work it did, and GEICO paid those invoices by what it contended was its payment parameters. During the trial, Susan Eberling on direct examination testified that in 2016, the invoices it received were paid pursuant to parameters. On cross-examination during trial, Ms. Eberling was questioned by Glasgow's attorneys about a 2012 pricing structure that was in place as to how GEICO paid. And that was the parameters by which GEICO paid. Glasgow sued GEICO because it wanted to invoice more than what GEICO paid. Now, importantly, the dispute hinges or pivots around a clause in the policy that limits what GEICO's responsibility or liability would be to pay for a covered claim. In this instance, this is a covered loss and GEICO paid. Now, the provision itself, neither party contends is ambiguous. But in 2018, the circuit court, in its appellate capacity, rendered its decision in Superior Auto versus Matthew Dick 1, which is attached to our appendix. That decision attempts to reconcile the terminology from the court's perspective that is in this limiting provision. Specifically, the provision will state the limit of GEICO's liability for loss will not exceed the prevailing competitive price to repair or replace the property at the time of the loss. Although you have the right to choose any repair facility or location, the limit of liability for repair or replacement of such property is the prevailing competitive price, which is the price we, GEICO, can secure from a competent, conveniently located repair facility. Now, in interpreting that, the 11th Circuit concluded the which clause that is contained there does not define the label prevailing competitive price, but instead it supports it. That decision became the controlling precedent for the small claims cases that were within that jurisdiction, which includes these 11. Now, importantly, in that decision, the court made clear what evidence was relevant. It talked about the price must be prevailing and competitive. It made clear that the rates proposed by glass shops like Glasgow, where there is no negotiation, is not the prevailing competitive price as it interpreted it. It also made point of saying that it is the cost in a competitive market in a normal arm's length non-insurance transaction. This decision has wreaked havoc both in this case, and it creates the evidentiary nightmare that we have, as well as other cases. And the reason for that is all the transactions, generally speaking, are insurance transactions. But GEICO has no way to present evidence on this. The case proceeded to trial, and Glasgow presented several witnesses who
I had a
testified.
question on that, your
Yes.
comment that, so in this market, basically you have the people who have a contract with an insurer to provide it, forget the guy's name, but the one that had both State Farm and the other pricing model.
Right,
and then you have the non-affiliated providers. But then there was some testimony, and I don't have it right in front of me, that there basically aren't any other players. There's not like you go down the street and say, hey, I want a new windshield, because all of the insurance policies in essence provide, because of state law, that you get your windshield replaced. So there's not like a standard market as though we would usually consider. I pick up the phone, I call 5 places and say, what are you going to charge me to replace this?
That's a fair statement, Your Honor.
Okay, so it would only be if I had a vehicle that didn't have insurance. I have an old car that I want to get it replaced, then I would be in kind of no man's land as far as a market is concerned.
Theoretically, another example would be you bought a car that you want to rehab and refurbish, and you need a windshield, and you would call up a shop to do the repair. There are no insurance insurance doesn't yet attach because the vehicle is not operational, perhaps. And then perhaps the shop comes up with the pricing that it would want to engage in. The expert or the shop owner, Radenbaugh, is the one you're referring to, who does we'll call it the set my price open market, and then the negotiated price with State Farm. Glasgow doesn't do any independent work. And so when you look at this provision, it continues on at your request. GEICO will identify a repair facility that will perform the repairs or replacement at the prevailing competitive price, which, if we go back to the which clause, defines what it is. It's the price GEICO can secure. And so it has
do all or most of the insurers, I guess at the time, this was 2016, was that an ordinary clause in most of the insurers' policies?
Sure. So I would submit yes, though that specifically is not in this record per se, but I would say that in the Gilbo case, which is a part of the trio of decisions that came out of the 11th Circuit.
You said 11, is it the 13th Circuit?
Oh, I'm sorry. My apologies.
Yeah, okay.
Yeah, my apologies.
I was thinking Atlanta or Miami as you're saying that. Okay.
And I don't
We're in Tampa here. Okay,
I don't think Atlanta decides very many windshield cases, but
exactly, not yet. Yeah.
But here, that does touch on a question I have. You know, the argument that you're making is dependent on 13th Circuit appellate precedent. We are a district court of appeal that has, more circuits in it than that.
Yes.
So are we deciding, this question, your case, based on how we would decide this case for all of the circuits in our district?
Well, I think,
and indeed for the state of Florida, to the extent that there's not another conflicting opinion or decision?
Sure, Your Honor. If this court renders a decision, that opinion does become binding on all the circuit courts, county courts.
But at this point, a decision I don't think it would behoove us to issue a decision that says the trial court messed up because it didn't observe didn't comply with the precedent in the 13th Circuit, because that's not going to happen again.
Yes, sir.
And so we're going to be really looking at this from a macro perspective, I suppose you'd call it, right?
Understand. And I think what's important for Your Honors to start with is looking at the standard that was in place at the time of trial. Does the evidence meet the standard articulated by the 13th? Thank you for correcting me. Yes, right. Your Honor, I apologize. For Hillsborough.
No need.
For Hillsborough. And we would submit it did not. It involved no negotiations. It involved insurance transactions. And again, the trio of cases that come out on this issue even refer to the type of transactions that are in play here, described by the corporate representative for Glasgow. And that is, we issue some invoices to 100 insurers, 95 of the insurers paid, 5 didn't. But what the 11th Circuit points out is even that doesn't
13th.
adequately address this issue. Yes, Your Honor.
The 13th, you keep saying 11th.
I apologize. In fact, I'm going to make a note here, put it on my screen.
Whenever you say
okay.
11, we'll
you just
think
had me thinking I missed some cases out of Miami or something.
Apologize for bringing you down to Miami on this. But getting back to the 13th Circuit. So again, in terms of that provision, the trial court applied Matthew Dick, Superior Order Matthew Dick, out of the 13th Circuit and set the standard. And that standard would exclude all the evidence that was proffered in this case by Glasgow. So the final judgment appears to rest on the evidence from Glasgow, but that evidence was neither relevant nor admissible because of the standards articulated by the 13th Circuit. Importantly, the only evidence that we have here is there were 11 automobiles that had 11 repairs. Glasgow invoice, Geico paid consistent with parameters it's had in place for several years going back to 2012. Glasgow never established that Geico didn't pay what it should have paid or that there was a breach. And so in that regard, we would submit the final judgment is not able to stand upon competent substantial evidence. The other area of concern here is going into trial, the court did not land on who was responsible, who bore the burden of proof. And there is an issue that I anticipate will come up on the response as to Geico asked for the burden, but the court said it's not going to rule on it. And then in the final judgment, it attempted to provide a burden on both Geico and Glasgow. The problem with that is if it truly was Geico's burden, I would submit that Geico should have gone first and started its case. But Glasgow went first. Geico did ask for the burden to be put on Glasgow, and that was consistent with other cases. And you see that in the Matthew Dick 2 decision that came out in 2020 out of the 13th Circuit.
I hate to keep interrupting you, but when you get to a point, I have a question. So I believe in the briefs show that both parties were really wanting to know whose burden it was, and then you would have known who should have gone first. Is that accurate?
I think that's a fair statement, Your Honor. The parties were left to guess.
Mr. Calabria may disagree, but he can talk about that point when we get there.
Sure. But I think that's part of the problem that's caused by these trio cases out of the 13th Circuit is it really hasn't provided clarity and guidance. A decision from this court would address those issues. And because there was that a lack of certainty as to who bore what burden, we contend in this appeal that it was unfair for the court to hoist it upon Geico without advance notice and then review the evidence. It's also unfair for the court to conclude that the evidence supports its conclusions when the evidence it used doesn't meet the test articulated by the 13th Circuit. I want to be real clear here that it needed under that standard. It needed to be negotiated, couldn't be insurance transactions, and it required some type of arm's length negotiation, none of which exists. Now, I will submit Mr. Rodenbar's testimony established during his questioning that there are agreements with these insurers and the so-called network affiliate agreements, which is something that even Glasgow acknowledged. But Glasgow doesn't want to participate in that because Glasgow wants to set its prices, charge what it wants, and not be bound by any type of limits that occur within the policy. So we would submit to the court that the evidence that was relied upon by the trial court was neither admissible under the standards articulated.
Yes.
Yes, ma'am.
And it's 8 up with updates.
I'm not sure who's speaking.
Same here. I don't know. I think we have a stray audio coming in. So just keep going, Mr. Franklin.
Thank you, Your Honor. So the evidence didn't meet the standard under Matthew Dick. It was therefore not admissible. It was not relevant to the standard. The only evidence that would have been relevant, and we would contend is relevant, is what Ms. Eberling testified to. But the problem here, as the court pointed out, neither side really understood, and there was this sense of fog around the situation. And the muddled, dare I say, mess caused by Matthew Dick 1, and even the subsequent decisions have created this confusion and this evidentiary nightmare. So that is why we've asked the court to reverse and to jettison those 3 cases because they do not articulate what the standards would be in Florida. The policy, there's no ruling. What's interesting here too is there's no ruling by this trial judge as to the interpretation of the policy, but rather it's following what the circuit court in its appellate capacity rendered. So in reversing it, it seems prudent, it would be prudent for the court to require a new trial, as well as jettisoning those other decisions and speaking to the issues that are before it. If the court has any other questions, I'd be happy to answer them, but at this point, I'd yield to.
I'll follow up with just 1 second on,
Yeah.
on that issue. You're asking us to jettison Matthew Dick, which was the 13th Circuit's case, where, you know, their standard was that it was negotiated with no one and it couldn't be Geico's negotiated rate. So since there's not really a market out there for someone else, what would you have us look to? Well, what is it you're suggesting? That there be, that look at all of the insurance companies and what they can get, or there's some, I guess it's the NAG or whatever that.
Sure.
The blue book for windshields.
The NAG suggested pricing, National Associated Glass Standards, I believe is what it stands for. I think in this instance, the trial court should allow the trial to go forward and Geico to present evidence of the prices it can secure. I think it should also require that the court follow the plain language of the policy, which neither party has contended it is ambiguous. I understand that in Matthew Dick 2 and Gilbo, there's a discussion of those issues. But as it relates to this, the problem with Matthew Dick 1, Matthew Dick 2, and Gilbo Robbins is these trio of cases effectively rewrite the policy. And so what we think would be most prudent here and in the interest of justice would be to allow the case to return, the court to hear issues on argument on that policy language, and then work its way through. Now, this court may ultimately address the issue, whether it's in this case or I believe there were two other appeals where those issues from either Gilbo Robbins or Matthew Dick 2 are up before it. But the evidence is, as it says, the which clause that follows the prevailing competitive price says which Geico can secure. Well, Geico can secure, as conceded in the brief, in the answer brief by Glasgow, Geico has contracts with entities. As acknowledged in the case by Glasgow shop owner and others, Geico has a network of shops. It has pricing that will fit within its parameters.
And Mr. Franklin, you're down to about 3 minutes of your time, and so you probably need to save some rebuttal if you want, or use them if you wish.
No, I had tried to yield before, so
I'm sorry.
We kind of stopped you there. That's why I'm stopping you now. So.
Yes,
all right, because I know Mr. Caldevilla is raring to go.
Yes, sir. May it please the court, your honors, I'm Dave Caldevilla. With me in my office today is my co-counsel, Anthony Prieto. We represent the appellee, Glasgow. As we explained in our answer brief, Geico is inviting this court to reweigh the evidence and disregard fundamental principles governing the standard of review, preservation of error, and the presumption of correctness. Basically, Geico's using this appeal to undo the results of its own tactical decisions. Under the standard of review, the trial court's findings of fact come to this court clothed in a presumption of correctness, and they can only be reversed if they're unsupported by any competent substantial evidence. This court's not allowed to reweigh the evidence or engage in any de novo fact finding. Geico's arguments turn that standard of review upside down and portray the evidence in the light most favorable to itself instead of the light most favorable to the trial court's determination. Now, it's undisputed that in each of these 11 each of the 11 damaged windshields, it was a covered loss. They've acknowledged that in their brief. So the primary issue in this case is whether Geico's payment amounts complied with the prevailing competitive price limitation of liability provision in the policies. Now, counsel says, oh, we were all confused about what the burden of proof was. That's not so. This has been litigated over and over and over again. One business day before trial, Geico filed a notice of filing, and they attached 4 or 5 trial court decisions that have no binding precedential effect. And those decisions ruled that it was plaintiff's burden to prove that Geico violated the limitation of liability provision. And we
Let me
briefed-
ask you this. So do you agree with Dick 1, Dick 2, and Gilbo, and you think that's what we should be following?
Well, we have to in this case because Geico relied on Dick 1. Dick 2 and
Well,
Geico.
let me ask it a different way. Do you agree with those and think that that's what this court should adopt?
Well, it's not.
As a
before this
standard?
court. This court cannot decide issues that were not presented to the trial court. That's just inappropriate. You have to give the trial court the right to make the decision first. Geico didn't come to the trial court, Judge
Okay,
Stradlin.
I understand that. So
Well,
if
I
you
mean,
look
I
at-
think, Mr. Calavia, in fairness, I think probably what you would prefer is we just don't adopt any standard here in PCA this thing, but assume we were to write an opinion, I think is what Judge Stargill is getting to. What would be the standard you propose we should adopt?
Well, first of all, again, to answer the question first, and I'll get to your question too, Judge Northcutt,
Well, that wasn't a question, really.
or your comment, I'll address what you're
Right.
saying, and I want to address what Judge Stargill said. Now,
Yeah.
Geico did not come to the county court and say, we disagree with Dick 1. This is the wrong standard. The court rewrote our insurance policy. That's not what they did. They filed a motion in limine relying on Dick 1 and saying the plaintiff can present no evidence in this case, and we can't present any evidence in this case of any insurance transactions because that's what Dick 1 says. Well, we disagree that that's what it holds. But Geico didn't say, look, we disagree with Dick 1, but we're bound by it. But you know what? We think this other standard should apply. And we know you're bound by this, trial judge, but you should follow this higher court level decision, or you should follow the evidence code or whatever. Or you should
Do
make
you
our-
agree with the trial court whenever in paragraph 3 of its order, it said the appellate court also indicated, and that would be the 13th Circuit opinion.
Are you talking about the limine, the order in limine,
No.
or the final
No,
judgment?
this is the court's order.
Okay.
Paragraph 3, the appellate court also indicated the prevailing competitive price is not a proposed rate that is not being negotiated with anyone. So do you agree that that should be part of the standard?
Well,
Not,
It
you
depends
don't
what you
consider
mean by
things that weren't
negotiated
negotiated.
with no one, because really, if that means that the price has to be haggled between the buyer and the seller, then no, that makes no sense. There's nothing magical about a windshield case, Judge Stargill. When you go to court about a case that involves a dispute about whether somebody's charging a fair price, there's nothing special about windshields that places them in a different standard. When you have a PIP case or a medical charges case, you come in with the bills, you present evidence, you present witnesses who say, yeah, this is the going rate in this community, and this is the prices that are charged, and these are the prices that are paid. The price is negotiated with no one. I don't know what that means. If they mean that, from reading the whole case in the context, what it means is that Geico made a special secret contract with Safelite to agree that Safelite and its affiliates would agree to accept deeply discounted prices. My client's not a party to that contract. The Dick 1 decision says, well, look, you can't say in your contract that your policy that you'll only pay a price you can secure when only Geico could secure that price, because Geico is the second largest insurance company in the country. They said that.
I mean, Amazon secures prices that nobody else can get because they have volume. Walmart secures prices that nobody else can get because they have volume. Now, I agree with you. I don't think you could lay that at the feet of somebody and say, go out and get one widget instead of 10,000 widgets. But
to your point,
when you're looking at what a comparative price that's conveniently located repair facility, if one of those places is in their market, why could that not? It may not be the entire factor, but why could that not be a factor? I mean, we know from the evidence in this case that State Farm has also made some secret squirrel contract or whatever it is you want to refer to it as. But this whole thing is different than a market. Your brief talks about a TV and walking into Walmart. Consumers walk into Walmart, they walk into Best Buy, they're looking at TVs. These people don't really care what brand of glass is going in there. They don't care anything about it. They want a new windshield.
I don't know where you see that, Judge. That's not in the record. But
What's that? I'm talking about in your brief,
about
your TV.
what people are looking for when they go to replace their windshield. The fact
I'm saying that people, it's not like there's a brand that has 14 different options that come with your windshield. That's not what
actually
people
there
are
are, you'd
looking
be
for.
surprised. You'd be surprised
Okay,
at what's embedded in your windshield. But
But the consumer is not the average
Judge-
consumer, according to what's in this, the case and the briefs I read, everyone seems to agree. They're more worried about what gift card they're getting to drive their business somewhere than they are.
there's no evidence of that, Your Honor, at all. And what is
Well,
in
there is
evidence, though,
testimony of that.
what it-
One of your witnesses said that they give out gift cards and other incentives to people to get their business into their
Mr.
non-affiliated.
Rathbone said that, but he didn't say that that's what all that customers were looking for. But let's get back to what the evidence is in this case, Judge Sturgill. There was 4 witnesses who testified. All of them testified that the prices we charged, that Glasgow charged, were reasonable, usual and customary, and well on the low side of what's being charged for windshields in this community. And we had an expert who testified. All this is without objection, by the way, without objection. He put in a report too that said that all of our prices were reasonable, customary, fair market prices, and below the prevailing competitive price. Geico presented no evidence of the prevailing competitive price. She did not testify that Geico, Ms. Eberling, their expert, their witness, not an expert, she did not testify once that Geico paid the prevailing competitive price. She did not testify once, hey, here's a windshield shop that would have accepted the price that we paid for these 11 windshields. They didn't testify to that. And they knew that this was their burden. This was no surprise. We filed, what was it, like a 20-page trial brief within 5 minutes after they filed their notice of these 5 trial court decisions about the notice, about the burden of proof. How do we whip up that trial brief in 5 minutes? Because we've litigated it multiple times. We cited dozens of cases. In fact, here's a case written by Judge Northcutt, the Mejia case versus Citizens Property, that identifies the burden of proof. The plaintiff has a burden to show that there's a covered loss, and here's my bill. And at that point, it's the insurance company's burden to say, wait a minute, our policy caps it, or our policy excludes this type of a claim. That is crystal clear black letter law from the Florida Supreme Court on down for years and years and years. And it's not special to insurance cases. Anytime there's a statute or a contract that limits or caps liability or limits or caps the amount of damages, it's always the defendant's burden to prove that provision applies. So Geico, the day before the trial, files this notice with these wrong and non-binding trial court decisions that they know are wrong. We file our standard trial brief that we file in all of these cases. And the trial judge was upset. The trial judge said, I don't even see these on my docket yet. If you were going to file a motion, you had to file it by the deadline in the pretrial order. We're going forward. They know what their burden of proof is. This was their tactical decision. They relied on the Dick 1 case in order to prevent us from putting on any evidence, which they knew it was their burden to put on evidence. The trial judge's decision, her order in limine, if you look at it, they claim that she did something different. The trial judge did exactly what her order in limine said she was going to do. And if she departed from that order in limine during the trial, then Geico should have objected and say, Judge, you're letting in evidence here that you held was being admissible.
When you say they relied on Dick 1, I mean, that was the law of the 13th Circuit there. But what would you have had them do? Argue that?
Like what I did in my trial brief on the burden of proof. I said, we recognize that there are these decisions out there, these trial court decisions on the burden of proof, but they're wrong. And you should follow this. This is what the higher courts are ruling. And this is what the higher courts have held is the burden of proof. Now, the Cordero case, interestingly, on the burden of proof, here's what happened. The Cordero decision which they relied on in their notice of filing the day before trial. Cordero decision was decided by Judge Berkowitz. Judge Berkowitz is a well-respected county court judge here in Hillsborough County who retired. The judge who took over his division is Judge Valkenburg. She's the judge who decided this case. So she's faced with a decision that her predecessor, well-respected judge, has held that it's the plaintiff's burden. Wrong. It's very clear that it's not the plaintiff's burden to prove this limitation of liability. It's the defendant's. But she has this decision, and a couple of other judges in Hillsborough County have also followed Judge Berkowitz. So in her decision, what does she do? She puts the burden on us correctly. Her paragraph 14 of the final judgment says, I agree with Geico. It's the plaintiff's burden. And I'm looking at the evidence, and the greater weight of the evidence shows that they did not charge, that Geico did not pay the prevailing competitive price, and that the plaintiff's prices did not exceed the prevailing competitive price. That's the greater weight of the evidence presented by the plaintiff. But then she goes further and said, but you know what? Because this was brought to me at the last minute, I went ahead and decided the case by putting the burden on Geico also, and I reached the same result. Why? Because Geico presented no evidence, none, no evidence of the prevailing competitive price.
Okay, but were they
tactical.
restrained by Dick 1, or you're saying that they should have just ignored Dick 1 and they could have argued whatever they wanted? You wouldn't have
Judge,
objected if they
when
said, I'm not going to
evidence
follow
is
Dick
excluded
1,
on
which
their own
limits.
motion, Judge, their own motion was to exclude their evidence, and now they're complaining about it. They filed a motion in limine that said we can't put on any evidence, and now they're complaining, well, we couldn't put on any evidence. It was their motion. They filed the motion. Now, if they tried to proffer evidence and it was excluded, then we'd see what's their evidence. But they're the ones who didn't want to present any evidence. Why did they not want to? Because they have none. Cases show it. The Edwards case, the Justice case, the cases that are cited in our brief, that there have been cases that go to trial and Geico can't prove up how they came up with it.
And that's where, I mean, what I'm trying to find out from you when it comes to Dick 1 and where it says that you can't have a rate that has not been negotiated with anyone, but yet this evidence came in here. And I know you can argue it, that was a negotiated rate, but all of the witnesses said, we didn't really negotiate it. We just threw it out there and tried to set a rate that we think most of them are going to accept.
First of all,
So are you saying that is the right standard or is not the right standard?
First of all, the witnesses testified, Mr. Bailey testified that his prices were negotiated, that 95% of all of the 100 insurance companies that he deals with pay his prices. Just like when you go into Publix and you buy your groceries, Judge Stargell, and they give you a price, you can pay that price, or you can walk out and say, I'm not paying that. I'm not paying $4 for half a gallon of milk. Well, that's your choice. But if you pay it, it's negotiated because you paid it. The same thing here. But the testimony, unobjected to testimony, was that it was negotiated. So Geico can't come in now and say, oh, well, this wasn't negotiated. They let that evidence in without an objection. And they presented no testimony, no evidence. They could have identified, well, here's 10 different windshield shops who in 2016, when these windshields were replaced, they would have accepted the prices that we paid. They would have accepted 50% of NAGs. Where are those windshield shops? That's their burden to prove it. We presented 4 witnesses who said, no, our prices were in line. Our prices on the low side. Presented an expert witness in a report. The report went into evidence. Judge Falkenberg asked Geico, you got any objection to this report? No, ma'am, no objection. That report, standing alone, even though we presented copious amounts of evidence, that report standing alone is competent substantial evidence to support the judge's decision. They can't come in now and object after the fact and say, well, that was inadmissible. No, the time to object that something's inadmissible is at trial, when somebody puts it in evidence and the judge asks you, do you have any objection? And you say no objection, then that evidence is admissible. It is competent substantial evidence.
And let me ask this. I mean, the Geico's brief is couched in terms of it not being supported by competent substantial evidence, but that's a different issue than evidence improperly admitted without objection.
Exactly right. And
So really the question posed by this case is evidentiary error.
it's not
and-
evidentiary error because they have not.
But what I'm saying is that what they're alleging is the evidence shouldn't have come in, and it's not, the evidence did come in, but if it hadn't come, so that
What they're saying is the evidence that came in, now looking at it in 2020 hindsight, we don't like that evidence and we think that it's not competent. Well,
Right.
not competent means inadmissible. And since the evidence is in evidence without an objection, it is competent substantial evidence. And we presented plenty of evidence. And again, Geico presented nothing about the prevailing competitive price. Ms. Eberlin, what her testimony was about, she was trying to attack the credibility of our experts' testimony. She wanted to testify, and she did testify. Well, Mr. Smith, he conducted this market survey, and he surveyed 24 shops, and all those shops have sued Geico. Well, a lot of shops have sued Geico. There's thousands of lawsuits against Geico. There aren't that many lawsuits. You can check windshield lawsuits against other insurance companies. And Geico wants you now to rewrite their insurance policy. They're going, oh, don't follow Dick. Why don't you reverse Dick? Well, they relied on Dick. They can't now come back to this court and say, well, we relied on it, but you should reverse it. If you do, that should be in the nature of an advisory opinion saying, Geico, you relied on Dick, and so we have to affirm. But, we question whether Dick is well decided, and here's why. That would be in the nature of an advisory opinion because the trial judge was never given the opportunity, and we were not given the opportunity to brief that. But what Geico's policy says, which they claim is unambiguous, says the prevailing competitive price is a price we can secure from any competent and conveniently located shop. Well, guess what? That's us. We're a competent and conveniently located shop. They admitted it. Their policy doesn't say the lowest price we can secure from anybody at any time, at any place. It doesn't say that. Other insurance policies from other insurance companies, by the way, do say that, do say the lowest price. But I would have to go outside the record to tell you that. But there are other policies not written like Geico's. If you reverse now and rewrite Geico's policy for them, it's without benefit of what other policies say. And so I suggest that this court should refrain from deciding issues that are not preserved for appeal and are not briefed, or not presented to the trial judge. What we have here is a circuit court decision that Geico relied upon and said no evidence should come in on this particular issue. They did that as a tactical maneuver to hamstring us, but the trial judge says, look, this is what's coming in and this is what's going out. This is what's being excluded. Any insurance company transactions where you have a blanket secret contract that says every single windshield you accept is going to be discounted, that is what Dick says you can't do, because that's a price that only Geico can secure. Only Geico can get, not anyone in an arm's length transaction, not someone off the street who doesn't have comprehensive insurance and walks into a windshield shop and wants their windshield repaired. They can't get the Geico.
You would have us accept the Dick 1 standard then.
For purposes of this case, you have to, Judge. Yes, you can't.
So, I question whether if you're saying, if you're saying it's prevailing competitive price actually could be limited by some captive kind of contract. That would seem to me to be contrary to that. But regardless, your 20 minutes are up, Mr. Caldavia.
Well, for the reasons presented today and the reasons in my brief, we request you to affirm. Thank you.
Okay, thank you. Okay, Mr. Franklin, you have 5.
Sure. Mace versus M&T Bank out of the 2nd DCA out of this court says competent substantial evidence requires it to be admissible and relevant. Matthew Dick 1 makes plain that the evidence that was introduced by Glasgow is not relevant as to what it should be paid. So whether you want to accept the argument that this evidence came in, it still was not relevant to the central issue. Number 2,
Matthew, there was no relevancy objection at the time.
There were no, to my
There
knowledge.
was no objection at all to the evidence being,
That might be the case, but I would submit that Matthew Dick acts as a guide for the court, much like a jury instruction as to how it should analyze that evidence, and that the trial court should have adhered to those standards. In fact, it said the evidence that would go to the issue would in fact be compliant with Matthew Dick. The evidence cited in the final judgment does not comply with Matthew Dick. It's number one. Number two, there are either rules in this case or there are no rules. If Matthew Dick is the rule, then the evidence fails that rule and what the standard was. If we have no rules, which is kind of what took place here with no one knew what the burden was, then we have a problem with the case. The reason that we asked the court to reverse is, one, there's no competent substantial evidence. Two, in reversal, we need to jettison those cases because they're not helping the situation. There is no evidence that Glasgow negotiated its prices with anyone. As to the statement about what Ms. Eberling stated on page 4268 of the record, she's posed the question, in 2016, which is the year these autos were repaired, how many affiliate and non-affiliate shops in the state of Florida billed Geico for windshield replacement? Answer, it was around 736, some more than 730. Question, did Geico pay those shops in accordance with its prevailing competitive price? Answer, yes. On cross-examination, Glasgow introduced the fact that Geico has a pricing structure that has been in place since 2012. That's on page 4290. In terms of the number of shops, the testimony from Ms. Eberling is out of 736 shops, 85 have sued Geico. There was testimony before the court as to what the prices were, but the standard enunciated in Dick, which bound Geico, and Geico is obligated to bring to the court's attention, creates a muddled mess here. If we go back to what we've argued, which is there is no competent substantial evidence, that means it was admissible and it was relevant. Their testimony, Glasgow's evidence was in fact not compliant and doesn't meet the standard articulated by Matthew Dick 1. Again, this trio of cases has created a bigger problem.
You need to wind up, Mr. Franklin.
Your Honors, Geico would ask that the court reverse and order a new trial, and that it would also instruct the court to not follow those decisions on the trio because they're not consistent with this court's opinions and other decisions in the state of Florida, and that the trial court should rule on the policy as it is written. Thank you, Your Honors.
Thank you both very much. In order to leave the courtroom today, you click the leave button, which is why it's called that. And then we'll be done. Take care, Mr. Caldevilla. Thank you, Mr. Franklin.